That is extremely problematic because, I don't know, do you want to have someone remix your song? They're like, hey, we suspect that you are using AI. We're gonna literally ask you to give us a live demonstration showing your work console and like what you do. I'm looking at this through the lens of you guys and literally all of you that end up contacting my law office because you're like, oh my gosh, they kicked me out of my account. They took my royalties. Oh, and by the way, I literally didn't do anything. I am very much about my community. I love you guys to death, and you have been asking about LANDR. Now, I started hearing about LANDR from my music producer clients and students, and you guys were just like, we use them for mastering, and there's like this AI mastering, and it's pretty good. And so I was hearing some good stuff. And I have been asked to review the terms of service. That's what I do on this channel. I like to look at the contracts that you guys have to sign in order to use these services, because usually you don't have an opportunity to hire an attorney to read them for you, and they're non-negotiable. So whatever they say is what you have quite literally agreed to. So that's part of my interest. I run a law firm. I read and draft terms of service all day long. So we've read quite a few of these. Now, to give you a little bit of a framework, we always have questions that we're trying to specifically address, because as I started exploring on the LANDR website, I'm like, oh wow, they do a lot of stuff, in fact. And so the questions that I'm keeping in mind, because this agreement is a combination of all the things that they do, right? Which includes music distribution. Had no idea. Good to know. Music distribution, you can get plugins, you can get samples, and of course, AI mastering, and they even can help you with your cover art. Like, wow. And so guess what? All that stuff has to be in the contract that you sign. And so here are the questions I always have as I'm going through. One, talk to me about the royalties. Anyone who is distributing your music to music platforms is a glorified bank. When that music distributor bank gets paid from the music platforms, they're supposed to pay you, right? And so I'm always really curious to just understand, how does it work? And basically with the forfeiture royalties, which has been a common denominator with these music distributors, in that a lot of them will say they retain the right to take your royalties for a list of reasons. So we're going to ask, what does it say about the forfeiture of royalties? I want to know about credits, because if anyone has used Splice, who we've talked about on this channel, basically LANDR's doing something similar, which is you can buy credits. With those credits, you can buy samples, and you can use those samples in your music. And so like we care about, well, does that mean you own the sample? Does that mean you get to do whatever you want with your song that contains that sample? So we're looking at that. And then lastly, we're going to discuss briefly about the plugins and basically how that all works. So without further ado, get your gavels and let's jump into it. Now look, I did something I've never done before on the channel. I actually, prior to starting this, I reached out to LANDR, and it was it was a couple hours before we actually started recording. So fair enough. They probably haven't even seen the email yet, but nonetheless, I want to preface by saying I did reach out to LANDR. I have some questions. I need some things clarified, and I always invite these music business companies to reach out to me for purposes of discussing this stuff. I'm happy to have you on my show. I'm happy to talk about the things. I am reading your contract within the four corners of how it exists today. So with that being said, terms of use. Let's make this bigger so everyone can see in the back. All right, so the company is LANDR Audio Incorporated and or Synchro Arts Limited. It says UK. As I was reading this, I'm like, yeah, this definitely seems to be UK or Canada. And then we do end up discovering that the jurisdiction for this contract is Canada. But let me go all the way down here. They put it at the bottom of the contract, which is the last time they updated this agreement was June 10th. We normally like to start with that. So very recently they made changes. So with that being said, the services include all the things that we just went through. Okay, so they are, doing a whole lot of stuff for you guys, which is so exciting. Like if ever I decided to start a music distribution platform or just some kind of platform that does all this kind of thing for you guys, this is exactly what I would do. I'd be like, I just want to make it a la carte, man, like mastering, music distribution, licensing. I guess there's like collaborations tools on their platform. They even have an educational section. And I was like, I didn't see anything about legal, right? But nonetheless, pretty cool. Anyway, so this is a contract. All right, it's always going to say this is a contract and you agree to it. You agree all the terms and conditions stated in the agreement. We get to make updates. Make sure you check back because you're going to check back on a link not. All right, your assets and permissions. We may collect, so they go on to just be like, we're going to collect information, and they kind of disclose information about their privacy policy. So normally these companies will be like, hey, just so you know, we're tracking you. And so we're going to collect information with like your personal data, your files, your content, your metadata, and like we might share them with applicable, third parties and our partners and stuff like that. But specifically related to the files that you upload onto these platforms, that's what I care about. I'm like, what can they do with your files, your stuff? Okay. So they define it as your assets. Okay, right here. So files, content, configuration settings, metadata, all this is hereafter called your assets. So the terms and anything that we don't specifically say, like you retain all your stuff. Okay. And they go on to say, please carefully review all the applicable terms in this agreement. And I just kind of paused on that. I go, well, that's why we're doing this, because we are together going to review these terms very carefully. All right, so LANDR goes on and they go, we need your permission to do all kinds of things with your assets, including backing them up, sharing them when you ask us to. The services also provide features for song previews, editing, sharing, searching, releasing. I mean, so we're fine with all this. They're like, look, for us to do the stuff that we're trying to do for you, you got to give us permission. So you are, in fact, giving us that permission. You authorize us to share information with our partners. This one right here, it goes, if you opted into our Fair Trade AI program, you give us the right to curate your qualifying music as part of our AI database. Now, here's the thing. On these platforms where I read stuff like that, and I go like we went through this with like the Sunos and the UDOs, reading their terms. And I think the most recent one was the updated terms for UDO. And they're like, hey, FYI, just so you know, when you upload your music to our platform to make new music, like you're giving us limited rights to do stuff with that, including to use the outputs for different things that we might want to use it for. And that's not necessarily like the end of the world, but for me, that jumps out because I go, if I upload my proprietary music, my copyrighted stuff, I don't want you doing anything with it. That's just me. So what they say in the LANDR terms of service is that they go, if you use what we call our Fair Trade AI program, we're actually going to give you a kickback. I was like, what is this? So they go, the AI model we train on, used in AI tools we develop and commercialize, and for which we will pay 20% of net revenue to program participants, proportional to their data contribution in the AI models that we host within our tech. I was like, oh my gosh, I love that. Participating users will receive their payout via their LANDR accounts. So this for me, already out the gate, there's a couple things that I'm loving. And you guys know that like in these terms of service, I'm not loving anything right out the gate. All right, so this is good. But just being like, hey, like just letting you know that if we are going to use your stuff to train on, you've opted in, all this good stuff, we're going to give you kickback of 20%. And I love that. Anytime that we can have a company that's benefiting off of you, you know what I'm saying? And they can give you some kind of participation. I think that's really cool. And the other thing that I kind of think cool, that I think is cool is that the way that they have worded the agreement is very plain language. So just meaning that a lot of these contracts that we go through, they're just, labored with legalese and big words and you know what I'm saying? And so it's very just like saying stuff for what it is, which I appreciate. That seems very artist-centric. All right, so sharing your assets, our services let you share your assets with others. So please think carefully about what you share. I mean, that's so just like plain language. I love that. You understand that you assume all risks, including unwanted public releases. Okay, we get all that. What content is shared with you, offering comments, suggestions, just FYI, like we're not going to pay you if you just go and engage in other people's content. Now, without written approval from the other party owning the content that was shared with you, you cannot share or reproduce the other user's content. So, so far this is all, I'm okay with this. Now they go on to kind of discuss the pricing, because something that seems to be kind of coming up over and over with these companies, including with Splice, the big outstanding question is like for you music producers, when you go and purchase samples on a non-exclusive basis, right? So you're getting it through one of these platforms. And we're like, well, you're going to like pay for these digital assets, which are like in your account. Maybe it's just credits. You haven't used them yet. What happens if you get kicked off the platform? What happens if you stop paying? And so, again, because this is literally what this company also does, we're going to see if they address that question. All right, so they talk about, if there's defective goods, we can, reimburse you, that's all good. And that's stuff that we see more for UK companies, like in the US. They don't care usually. They're like, no refunds. But I think it's actually mandated in the UK. So let's go into copyright of intellectual property, which is they go, here's what you cannot do. You can't upload, share, release, or otherwise use any of the services, any content, including audio files, samples, recording, for which you do not own. All right? We don't mind about that. If you don't respect this rule, you assume all risks and all the bad stuff that's going to come with it. We reserve the right, and this is, the first time that we're going to see this. We always care about where it says in these contracts. We reserve the right, LANDR or whatever company it is, to disable your content, your account, and there's going to be a couple places that we see this. Okay, and that goes to our, concern about, well, if a company reserves the right, which we understand to a degree. If you do something bad, a private company should have the right to kick you off their platform. But my problem, what I look at, with these things is I go, well, if you kick them off the platform and they lose all their credits and they lose all the financial investment that is made into this account, are you going to reimburse my client? So in any case, this is the first time that we see it. And they're like, hey, we do reserve the right to disable your account. If there's copyright infringement, you can email us. Here's the email. So now we're going to get into the samples because I just went to town on Splice and the language that they had, because I go, if you guys are going to purchase samples to use in your music, I need to make sure that you can actually use it without problems. You can get other people to remix it, you can sell it, you can license it, because it's just, not the best thing if you are like getting a license for a sample and they're like, oh, by the way, you can't sell it. So within that context, that's how we're looking at this. So they go, our sample services, we do royalty-free sample libraries. You're allowed to use the sample so long as you follow our terms. Okay, that's good. To download a sample, you have to comply. You're going to redeem credits, very similar to Splice. You need credits to download the samples. If you download a faulty file, we'll like replace it for you. Okay, so then it's all going well, but then we get here. We want to make sure your samples experience is as smooth and easy as possible. Therefore, under the terms of the agreement, you're given, this is really important, you are given a non-exclusive, worldwide, royalty-free, perpetual, non-transferable, and non-sublicensable license. And it's not spelled wrong, by the way, that's just UK spelling. Let's just take a beat. Okay, this is essentially what ended up getting my channel a strike from Splice, because I honed in on very similar language that they had in their terms of service in regards to this issue. And I go, if you are giving a license for someone to use a sample that is from your library, I really need the license for my client to say that they have the right to use it in the music without restriction. I think that's fair. Where I kind of went to town on the other company was because it had said that it was non-transferable. And I go, that's not sitting well with me. I understand kind of like what you're trying to say. Like if me, Miss Krystle, I go and download the sample and I put it in my song, the right for me to download the sample is the right that's not transferable, right? That makes sense. But there was conflicting language that just went like as far as using the final song with the sample in it and then selling it. You can't transfer the license to the sample to someone else. So that's what we went to bat to. So going back now to LANDR. So we go, they're like, this is royalty-free, perpetual, but they go, it's non-transferable. So there's that language again. But they also say it's non-sublicensable. That is extremely problematic because I don't know. Do you want to have someone remix your song? So if Miss Krystle gives the song to Johnny's a great music producer. Johnny remixes the song, and it just so happens that the sample is in one of the stems that I gave. So, I mean, what does that mean for me? That means I need to go and remove the sample before I give it to Johnny to remix. So that's also why I reach out to these companies, because I go, this is what it says. This could have been missed by your drafter, your lawyer, I don't know. But that is what it says, okay? And that's a problem because my whole job is to make sure that you guys can use your music without restriction. And then eventually when you have a big hit song and the label comes And the label's like, hey, that independent artist who got 50 million plays on their song, we want to buy your song. And we're going to re-release it as a collaboration with someone else. Like, literally, this is what we do. And then we're like, oh yeah, by the way, we can't give you the sample that's like the main part of the loop, So that's why I'm going in on this, because it really matters that much. All right, so it does say that, and they go, it's not sublicensable. You can reproduce the samples with or without modification, or you can't. And they go on just to define, basically some restrictions. So they go, for clarity. I like clarity. Cool. What else are they going to say? The sample license allows you to modify, reproduce, distribute, transmit, publicly perform, or display, communicate, or make available to the public, or otherwise use the samples, but only to the extent they are part of your recordings. And please be aware that it is your responsibility to own or have, obtained the rights to the rest of your song. So the music is yours. Okay, great. This means that you keep ownership of the song, of your stuff that uses the sample. So I just want to make sure this is super clear. So when you sample someone's song and you get a license to that, you have a license to use the sample. You still own everything else that was created around it. You don't own the sample. So that's what they're just reiterating. I'm fine with that. But now I still have this in the back of my head. I'm like, okay, maybe they're going to clarify this later on in the agreement about the whole non-transferability. So keep in mind that the sample license does not allow you to use any samples on a standalone basis or in isolation. Okay. Such as sound effects or loops. That's not ideal for you music producers. If you guys are specifically getting hired to do sound effects for TV shows and stuff like that, that's what it says. Okay. They go, no can do. But it also, you are not allowed to sell, loan, lend, share, give, broadcast, rent, assign, or otherwise distribute, transfer, provide, or make available to anyone else samples except as incorporated in your recording. So, right there, I just go, okay, this is where I really would like LANDR to clarify. Maybe they need to just update the terms of service a little bit, because if they are okay with you selling your song outright. So again, Miss Krystle, I'm going to sell my song outright to record label Universal, let's say, then I have to be able to give them permission to the sample that I put in the song, right? So that's not, at least right now, at best we can argue and just say that the terms conflict in regards to that. But then they do go on and they're like, except, as you kind of incorporated the sample into your song, you should be good to go. It's just the four corners of this. What it's saying is that you, Mr. Producer, as you're sitting there making your song, cool, you can distribute it, use it however you want. But there's so many things that happen downstream, remixes, actually selling outright your beat, whatever. And that's where they're cutting you off at the pass. Become your own record label, which is literally, if you're like, hey, I want to start a record label. Cool, I got you. Understand the entire music business. I want to set up my LLC. I want to do the marketing. It's a lot. So for example, sync licensing, for example, music marketing, it's significantly cheaper than anything you would ever get from a law firm as far as all the stuff that comes with it. And you want to make 6 figures from your music career and you want to do this for real. I'm going to give you what you need. In addition, any author, composer, performer that has produced the samples, just so you can't just go and use people's names. All right, so if you find out who actually made the sample, you can't release a song being featuring. I think that's reasonable. I don't have a problem with that. So real quick, let's just jump into the plugin stuff. So they go, the plugin service is curated, but they make super, super clear just to be look, we're basically connecting y'all. So whatever plugins that you use, we're making no warranties about it's gonna work, that it's not infringing someone else's rights, that it's error-free, that it might carry a virus. We don't know about any of that. We are just facilitating the relationship between y'all. So just so you know, that is what they say, okay? And then they go, you can pay the full price upon getting it. You can do a rent-to-own payment plan. So just look on the website if this is something that you're interested in. I know my music producer does kind of rent-to-own types of things with plugins. One of the questions just practically that they do address, they just go, if your service is interrupted, so meaning, you stop paying, you will lose your monthly license and your plugin will become inoperable until you restart your monthly payments. Now, I liked that they addressed this and they're just look, if you're not paying for it, you don't get to use it, but they're not going to kind of cut off your right altogether where you get locked out of your account or your account gets deleted. So I was happy to see that. It's just reasonable. I'm looking for these companies to just be reasonable about how they treat their customers, specifically their artists, their music producers, stuff like that, I think is within the reasonableness framework. All right, please understand if you don't comply with this agreement, you will likely be at risk of giving up your rights to the plugins. If that happens, we'll reinstate once you resolve the issue and pay up. Okay, now distribution. All right, I know some of you are like, finally, this is long. I understand. You're doing great. All right, so for the release and distribution services, there's lots of language in here, okay, that they always go through this and they're just like, you give us rights to the limited right of actually distributing your stuff. We have to be able to control, and do what we need to do. But they get into releasing to the actual DSPs, the digital service providers. So we will make your stuff available on the music platforms, but in many instances, you will not be able to select the countries or geographical regions in which your recordings will be made available. That was interesting to me because in a lot of the music distributor accounts or distributor services in general, they do give you that right to limit your distribution. Now, I don't know if maybe LANDR's just kind of newer. I know they're newer with some of this stuff than some of the other competitors. And this is getting a tiny bit nuanced, okay? I am entertainment attorney. I've been doing this for 10 years. I've had a lot of these situations come up, but sometimes we do have issues, right? Because under the laws of Russia, there might be a problem with the cover song that the client released. And so sometimes we actually do need to go in and limit the geographical region. So I pointed that out because practically speaking, I've had situations where this has become important. But what they say is that, just understand we're basically going to distribute this worldwide. And that's how most people do it. Okay. So just pointing it out. Digital stores may choose not to carry one or more of your songs. Okay. We can also decline, basically any of your music, especially if we receive legal claims. All right, so now we're getting into the whole basically as soon as a distributor in their contract starts talking about if we get legal claims, if you do something naughty, that's usually when they start talking about your royalties. So let's see what LANDR has to say about it. All right, so they first kind of go into this little conversation about cover songs. Now, this is where I was like, oh, I think this might be like a UK or Canada company because they're specifically discussing the need to seek and get a cover song mechanical license. And just quick little side note for those of you doing cover songs, the way that it works in the United States, you can do cover songs and you don't need to get a mechanical license anymore, with a little caveat. So you used to have to get it every time you did a cover song. And then what happened is that the Music Modernization Act of 2018 came about and they're like, hey, no one's getting these mechanical licenses and there's like all this infringement. So they changed it and they ended up setting up an organization called the Mechanical Licensing Collective. And they go, look, this is the new little government entity that's going to do the deal with the digital service providers like Spotify, right? Like Apple Music. And the DSPs are just going to pay this entity. This entity will then pay the publishers and the songwriters. And so we're just taking artists out of the mix. They can just do their cover songs and they don't need to worry about this for music platform distribution. Okay. That's how it works now. And that little wrinkle, that little, carve out that I mentioned is just in regards to physical products, CDs, vinyls, and digital downloads of the song. So if you're like one of my peeps and you sell your stuff on your own website, you do the direct to fan model, you may want to get a mechanical license if you're actually selling CDs with cover songs on them. But generally speaking, most of us will just do a cover song we put on Spotify. And so if you do that, you don't have to get a mechanical license. Now, I say all of this because in the agreement here, they're talking about how they're going to go get cover song, licenses. I'm like, why are you saying that? You don't have to do that as a distributor. I'm like, okay, they must not be in the United States, one. But two, at least from the research that I did, I think that there is the Mechanical Copyright Protection Society, so the MCPS, which is the same version of like our US entity, but that's in the UK. So anyway, I need to dive more into this, but my understanding is that it's kind of similar. Basically, what they say is like, you can pay us, we can, or not pay us. We will look into doing like the cover song licensing. I don't know that they actually need to do that, but I pointed it out nonetheless, and then just wanted to give you guys that overview in regards to at least what we do here in the United States. All right, so now let's talk about cover art. One of the most interesting things that you guys have asked me, especially when AI started to become just really popular, it was just like, look, if I do AI cover art, what's the downside to that? And one of the things we talked about is just that, you don't have copyright protection in it. Now, as far as using LANDR to make your cover art, this is what they have to say. So they go, AI cover art, LANDR retains ownership of the outcome generated by our AI cover art generator until the cover art image is officially utilized for a release through LANDR. I'm like, well, what if I release it somewhere else now or later? So that, I didn't love that. Upon release, the owner of that release obtains full ownership of the cover art. I would argue that you release it through LANDR if you're using their service, and then you own it. And so if you take out, you take your music elsewhere, you should be okay. But that stood out to me because, again, I'm like, I don't know, is there a way just to use your AI generator for cover images and then I don't release my song through you? Just saying. All right, we reserve the right to distribute or to refuse to distribute your content in our sole discretion if we suspect you are up to no good. I thought this was interesting. They go, we reserve the right to audit your creative workflows and projects and require a live demonstration of your digital working environment prior to accepting a release. And I'm like, that's so interesting. So if you're an artist and you use Udio to make your song and you have not input anything, you haven't even, put in your own original lyrics, and then you use AI to do your cover art, it almost sounds like LANDR's not okay with that. Now, that might not be the case, but I thought it was just interesting that they literally pointed out, they're like, hey, if we suspect that you are using AI to create like everything, we're going to literally ask you to give us a live demonstration showing your work console and like what you do. That's interesting. I've never read that kind of thing before. All right, payments. All right, so at least as of now, they're saying there's different versions. They have a version where it's like you get 100% of your net income, right? So anything that's generated after, the DSPs deduct their fees and stuff like that, and you just pay a one-time fee for the release. They also have another version, which is a la carte. And so you pay, or I should say you do a share of 15% of the commission, you pay a different fee. So just look on their website because obviously with these companies, this changes over time. All right, so look, some of the other things you guys should just know, they go with your trademarks, your name, you promise, you own all this stuff. Please pay attention to this. They go, we may provide UPC and ISRC numbers. So, if you use like basically any of these platforms like DistroKid, when you're uploading your music, they'll be like, hey, do you have an ISRC number, which is the international tracking number for your music? And you'll be like, no, I don't. And so they will assign you one for free. What LANDR says is they go, the codes that we provide to you are like personally for you, okay? But they specifically say you cannot transfer them to someone else. Again, this goes back to my whole, you guys are trying to make money with your music. You sell beats. You sell songs, right? And some of my clients who have just had really big songs, they end up selling the music and the ISRC numbers carry with the music, right? Because, the whole thing is that it has 50 million plays on it on Spotify. So the purchasing person or company wants to be able to take over the release and they have to use the same ISRC number. So I didn't love that because it does say you cannot transfer your ISRC numbers that they give you to someone else. All right. So that's for, as far as like we're working through this, there's lots of great stuff. But for me, that's kind of strike two. I don't like that. All right, here we go. Grant of right. LANDR works on your behalf as musicians and creators. So you are not assigning or transferring any copyright ownership of your music to us. You just give us a non-exclusive license. Okay, we're fine with that. And they give you a big list. Most music, distributors do this. Like you give us the right to, use your name, send it to the DSPs. We're okay with all of this. Your responsibilities. Please stop, don't steal stuff. Please don't get us, copyright striked because of your songs. We're fine with all of that. All right, so here we go, because they took us on this whole detour. I thought we were getting into the royalties and all this stuff, and we talked about cover songs for a while. So now we're at the part where it goes claims for infringement, which is always where our spidey sense starts to go off. We're like, we're going to talk about the royalties, and we hope that they're going to be fair about this. I don't know. This is what they have to say. So if we receive a notice about your music, okay, and there are claims of bad stuff, all right, copyright infringement, trademarks, right, publicity, whatever, we have the right to do all the things, including to remove your music. We can remove your metadata, and we can basically, until we receive sufficient proof in our sole opinion that you have satisfactorily resolved any outstanding issues related to such claims during this period, we may freeze the net income of your account if we believe, using a reasonable judgment, that you may have violated the terms of this agreement. So we have seen so many variations of this, and the most aggressive, and I said this yesterday in an interview, and I'm like, the most aggressive with a music distributor by far is TuneCore. And, they're just like, if there's even a claim of any kind of impropriety of any kind, no one has to prove anything, but we're going to freeze your account. We have the right to kick you out. We're going to forfeit your royalties. And we not only can just keep them, but we can pay them to third parties. Like whoever we want, we're just going to send your royalties to someone else. We have a problem with that. And then across the board with a lot of these distributors, they usually, some are less aggressive, right? But they'll just be something like, we reserve the right to, in this case, they're saying freeze the account. So that means you lose, the ability to withdraw any funds. But I haven't seen so far that they're just going to forfeit your royalties. All right, so let's see if we get there. So if we determine, the recordings, the cover songs, whatever you're doing, that there's been all, some naughty conduct, we can deduct from any amount payable to you any resulting costs for us, including legal fees and expenses, or seize and keep the net incomes from your account without renouncing to the other rights and remedies we have. So there it is. They said it a little less insultingly than I've read, but they're like, basically, it's our decision. And if we decide that we're going to go ahead and seize, TuneCore likes to forfeit, they're going to seize your net incomes. They reserve the right to do that. All right, so they go on to talk about fraudulent, infringing, illegal activities. So they're just continuing on with all. If you do any of these things, we can deduct any amounts payable to you resulting, from our costs, including our legal fees, or seize and keep the net incomes from your account without renouncing to our other rights and remedies we may have. Let's just real quick. My general opinion with these companies is that if you do something that gets them sanctioned by Spotify, because you were paying for fake plays, if they have damages that they need to now go and pay because of you, and they can prove it, I don't have a problem with them going and deducting those damages from your royalties. It's a breach of contract. And that's how I look through this. I go, if there's a breach of contract and there's harm, is it okay for someone to say, this is the harm, and I'm going to recoup those amounts? I don't have a problem with that. My problem is when it's just this like blatant net that is cast of like, in our sole discretion, if we even think there's been some kind of a propriety, we're going to seize, and we might just keep it all. So that's my problem. I'm not saying that, I don't understand why these companies do it and they give themselves the most flexibility, but like at the end of the day, I'm looking at this through the lens of you guys and literally all of you that end up contacting my law office because you're like, oh my gosh, they kicked me out of my account. They took my royalties. Oh, and by the way, I literally didn't do anything. And this was a glitch. Or someone made a claim and it wasn't even a legitimate claim. All right, so a couple other reps and warranties. You have to be at least 14 years of age. You agree to hold LANDR and its licensees and officers and all the people harmless. Now, here's our big question. At the end of the services, what happens? You're free to stop using the services at any time. We also reserve the right to suspend or end the services at any time without notice. Yikes. Now, we're already past the credits section, where they're just like, you can buy credits and whatever. And because all I can do is infer a negative inference, just meaning they have not said that if you get kicked out of your account, if they delete your account or whatever, that they will reimburse you the credits that you have already paid for. So I can only assume from the lack of addressing it that you don't actually get that money reimbursed. And if that's the case, I don't like that, right? You have literally like put money into the account. And so I think that if they ever kick you off the platform, they should reimburse that. If you haven't used the credits, just my opinion. And they just go through the procedure, right? So if we delete the account, this is what's going to happen with the takedown to the DSPs. But they also go, we'll delete your account if you don't do anything in it for 24 months. They're like, if you're not using it, we're just going to delete it. So that goes to my whole like, well, what if you've invested in plugins? What if you've invested in credits? And this is probably the final note that I'm going to make on this. Okay. And this is the closest thing to TuneCore that I have to date found from another distributor, because one of the things in the TuneCore terms that we're just like, oh my gosh, is that TuneCore has language that says, while they have your royalties, they will put it into an interest-bearing account. So what they do is that they make interest off of your money. And guess what they do with that interest? They take it. And I'm just like, look, business people be business people making money. What are you gonna do? But I'm just like, obviously I just would appreciate these companies doing something like, to LANDR's credit, being like, hey, if we're gonna like use your stuff for our AI training, we'll give you like a 20% kickback on your prorated contribution and all the stuff. But anyway, so here what they do go on to say is they go, you understand and accept that we will pay no interest on any amount that we retain that could be owed to you, even if we might receive interest or earnings on such amount. It seems like it's the same thing of what TuneCore is doing, that they may be, using your royalties in an interest-bearing account and taking those monies. And so they're just like, hey, just so you know that if there is any interest, like, we're not going to give it to you. FYI. All right, and then here's all the good stuff, right? Boilerplate, disclaimer of liability. You take all of our stuff as is. We have no responsibility for your cover songs. You waive your incidental, indirect, consequential, special, or punitive damages. Oh, and by the way, if you do decide to try to sue us, the most that you can get shall not exceed $100. So you come and see me and you're like, Krystle, we need to sue the pants off of them. And I'm like, okay, cool. So the retainer's like $5,000 and this litigation's probably gonna, cost like $50,000. According to the limitation of liability, the most you can seek is $100. There's stuff that appears in all these agreements, and it's to protect these companies from you guys and your claims and whatever. It's just, so I point them out so you're just aware. Modifications, we already talked about this. They just make changes and they'll update them on the terms, which is linked on the website. Online materials, this one kind of made me laugh. They should really update this. They go, the materials published on our website are solely for your personal and non-commercial use. I'm like, isn't your samples and plugins and all the stuff technically on your website? You really should update that, because that's like, I don't like that. It says non-commercial. We want commercial for everything. So you need to clarify what that means. Excluding our samples, excluding our, plugins. All right. And then finally, they do say, they're like, hey, if there's any kind of like problem, you're going to litigate in Canada. So that answers that question of where this all is. And lastly, guys, this is the big one here. It goes, you shall not assign or otherwise transfer this agreement or any of its rights or obligations hereunder to any third party without the prior consent of LANDR, which consent is basically up to us, and we could just say no. All right, so and lastly, contact information. If you ever need to send them a legal claim, I'm always going to tell you guys this. These companies hate me because I show you how to contact them, but this is how you contact them. So this is their physical address. Here is their email for legal claims. So look, here's my recap, because here was the mission. Let me go back to my little paper that I have wrinkled to oblivion. The mission was, let's talk about the forfeiture of royalties. Do they, in fact, have forfeiture of royalties language? The answer is yes. Except they call it seizure. They're going to seize your royalties. We had a question in regards to the credits, right? So the access issue, what happens if your account gets deleted? What happens if you stop paying? And so that still is a question mark. But again, I can only infer that based on the not addressing it, that when it says we're going to delete your account for any reason, that if your account gets deleted, the credits, right, and your investment into that account would continue, or be attached to that. And then otherwise, there were a couple of ouchy moments. All right. So here's what I'm going to say to try to be fair. I always want to give these companies an opportunity to update their terms of service. And once they've updated their terms of service, to come back and be like, hey, our intention, for example, if this is the case, if this is even the truth, our intention is that we want our music creators to be able to use our samples and to do whatever they need to do with their music. We're clear. We don't want them to just take the samples and put them in sample packs and resell them. Don't do that. But if it's contained in the final recording and then someone needs to remix it, or an artist or producer wants to sell their song, I would like the terms, if that's the case and you guys are cool with that, the terms need to say that. They don't say that. I don't love the forfeiture of royalties and the seizure and whatever. But one thing I can at least share, and I'll close with this. One thing I can share is that with these companies who I actually deal with, right? We're suing, we're litigating, we're lettering. And, when I get on the phone with a company, let's say like DistroKid, who's also a music distributor, and I've said this to their legal department, and I just go, look, I know that in your terms, there's stuff that I'm not happy about. I've said this on my channel. I've reviewed your terms and this and that. But my practical experience with the company has been that 99.9%, actually no, it's 100%. 100% of the time when we have dealt with DistroKid for purposes of getting royalties released and just helping our clients to get a favorable outcome, they're very reasonable. They work with us. Versus when we've dealt with a company like TuneCore, it escalated to such a degree that it became a series on this channel. There's the paper and there's the terms of the contract, and you need to know what they say, which is why I do these videos, but also just like how the company responds and what they do once they get wind of these videos is really important. And once they actually deal with me, because now I'm on the other side of one of the cases. So that's an update to come. I hope I hear from LANDR. Guys, leave a comment down below if you want LANDR to reach out, have a conversation, update their terms of service, and I'll see you guys on the next one.